Hey everyone, it's Rob Stanley with the Ecom Wiz podcast. And today I have a great guest on, Rich Goldstein. He is principal attorney for Goldstein Patent Law. Hey Rich, thanks for being on the podcast.
Hey, Rob. Good to see you.
Good to see you too. So actually, it's been a while since Rich and I saw each other, and we set this up quite a while ago. And the reason I wanted to set this up and kind of help people out is a lot of times people kind of ask, like, how do I protect my Amazon product and brand? And in particular to, let's say, patents and trademarks. So I wanted to get Rich on here. Rich, let's dive straight in. First of all, let's tell everybody what the difference between a patent and a trademark is, and then let's jump right into what can be protected with a patent and trademark.
Okay, awesome. So the difference between a patent and a trademark is the subject matter. They both protect different things. So people often get confused about those two, and they'll say something like, that's a great name for a product, you should patent it. Or they'll say, hey, that's a really cool product idea, you should get a copyright on that. And it just shows that there's a mismatch between the subject matter and the thing that you're using to protect it. So an easy way to remember it is, when you think products, think patents. When you think branding, think trademarks. So basically anything that has to do with a product idea, a different way that a product is structured, even a different shape for a product, that would be what you protect with a patent. And when it comes to branding, like the name of your product, the name of your store, the logo, things like that, branding elements, that's all trademarks. And so you'd want to always protect that with a trademark.
Gotcha. Yeah, that's good to understand. And then what can be protected with a patent or trademark? You kind of went over it a little bit more, by giving it kind of a definition of each of those. But is there kind of weird things that come up, let's say with Amazon sellers, that maybe you're just like, hey, you want to either trademark that, patent it, but you didn't mention copyright. Is that different also?
Yeah, and copyright is for content. So images and even the wording on your listing could be copyright protected. So that's copyright is how you protect content of all kinds, whether it's imagery or the wording in your instruction manual, or a movie or a song. Like content of all kinds is protected with copyrights. But generally for sellers, the things they need to worry about are patents and trademarks.
Gotcha.
And again, the patents are for the product ideas themselves, where the trademarks are just for the branding, the name of the product, or the logo that you use to present the products or your company.
Gotcha. So I know this comes up a lot, and I'm going to ask the question, like, if I take pictures of my own product that I created, are those pictures automatically copyrighted, or do I have to apply for a copyright on those pictures?
Oh, very good question. So, I mean, technically under copyright law, it is automatically copyright protected. So under the copyright laws, once something is fixed in a tangible form under the law, that's when it becomes protectable. So protected. So if you're writing a book, the minute it's out of your brain and becomes words on paper, or words that are saved in a file for the book you're writing, or if it's a painting, the minute that the paint leaves the brush and actually is on the canvas, once it's fixed in a tangible form, then it's copyright protected. You can take the further step of registering your copyright by filing it with the Library of Congress. And there are certain advantages to doing so. It's one of the ways in which your copyright gets recognized. So Amazon will typically look for a registered copyright. Even if technically under the law it is protected, sometimes it's just a matter of having that certificate because someone is asking for it.
Gotcha.
Yeah. And by the way, the difference is that it was protected under the law. That means that if you brought a lawsuit about it, you could you can prove that it was already protected. But we're not talking about lawsuits here. We're talking about a bunch of other procedures where sellers need to show what they own to get someone else shut down. And so that's where the copyright certificate comes into play. So it doesn't even technically matter if it's really protected or not when it's, whether it's protected or not automatically. It's more a matter of like, well, what does Amazon want to see? They want to see a copyright registration.
Yeah. And what about videos? Those are copyright also, correct?
Yes, yeah. Works of visual arts, including video, would be protected by copyright as well. Yep.
Gotcha. So if a seller on Amazon, let's say somebody puts a listing up, takes their pictures, maybe even modifies them or covers up their logo and maybe even their video or something and puts it up there, they violated the copyright of that person who shot the original video slash images, correct?
Yes, exactly. And I don't do takedowns like that. I know that
Yeah.
there are many lawyers that do. But yes, I know many sellers that have been very successful, though, in getting hijackers taken down for those reasons.
Nice. Yeah, that's good to know. So when people are first starting, let's say they're starting to get their business going and they want to create their company name and maybe a logo to go with it. That is something that they would want to take into consideration. Now, we do probably see a lot of times that people think, I'm never really going to be a big company or a big seller. And then overnight or, within a short amount of time, it blows up and they are like, oh man, is it kind of something is when they're starting that process, is it good for them to look at getting that trademark on that name and possibly, I think if you said correctly on the logo is a copyright on the logo you said?
No, it would be a trademark. So
Trademark. Okay.
basically, any of the things that you use, any of the branding things, the
Yes.
things that you use to say that this is my company, this is my product, those are protected by trademark. So let's Feedback Whiz. The name Feedback Whiz is a trademark.
Yep.
Right. The logo with the lettering, the word feedback over the reversed word whiz in a block of text,
Yep.
like that's also a trademark. So these things that if a competitor were to copy them, it would kind of put consumers in a position where they might be confused and say, wait, is that Feedback Whiz? Like that name sounds very similar to Feedback Whiz, or is that Feedback Whiz? Because okay, it doesn't say feedback, but I know that logo. It says like feedback feedback guy or something, but it's in the
Yeah.
same style. Then that would be a trademark violation because consumers would be confused and saying, oh yeah, it was that company. I went to their booth and I know them and they do a great job. And but if they're mistakenly thinking of you when it's your competitor, that could be a trademark violation. So basically the name, the logo, it could be a slogan, it could even be a color scheme, or trademark protectable. And going back to your question, like a beginning seller that says like, hey, I've got a name for a company and should I bother trademarking this, or I'm not really going to be that big. I mean, lots of people start out that way and think that it's not going to go very far, so maybe they shouldn't bother. But when it comes to trademarks, I think it always pays to protect your brand. It's different advice that I give than patents. Patents doesn't always make sense, but trademarks always protect your brand. It costs a lot less money, costs a couple $1,000s typically to soup to nuts to get your trademark on. You should do it, and then with Amazon, you have a registered trademark, you can get into brand registry.
Yeah. Yeah. Then now I remember when I did trademarks for my companies, and correct me on the wording for this, but there's also kind of like a word trademark where you're not actually, if you decide, let's say with Feedback Whiz, we decided to make it look a little different instead of the blue sort of square over the whiz part. We wanted to change that maybe down the road. There isn't it like a word type or word trademark or something like that instead of sort of the logo of the wording?
Yeah, absolutely. And so often you want to do those separately. So so there's a word mark, which is just for the words.
Okay.
Feedback Whiz, doesn't matter what font it's presented in, what style. If something is confusingly similar with that word mark, Feedback Whiz, then that would be a trademark violation. You often would do a separate application. It pays to do them separately, typically, for the Feedback Whiz logo. And at least for now, that logo matters to your company. And so you want it protected, but 3 years from now, you want to change the logo. You might want to do a new trademark for that. But the original wordmark one is still intact. And so you know you're still protected with the original wordmark one for Feedback Wiz. But now maybe the logo one isn't as useful, and maybe now you do a new logo. So that's
Yeah.
fine. But yes, you're absolutely right. You generally want to start with the wordmark and protect the brand name as possible.
Gotcha. And then what about also if I am, trademarking it, and let's say I'm using a font that maybe I got off the computer, is there could be issues also if you're not using, let's say, when you're trying to actually protect the way it looks, right? Like Pepsi, for instance, or Coke, they have a specific trademark that is on the style of the way the lettering is. Don't you have to
Yes.
also be careful on that? Because if people just go out there and start grabbing fonts off their computer and trying to trademark that, you're trying to trademark a font that's already been trademarked, right?
Yeah, I mean, and it's that's kind of in the category of the logo, let's say. So the
Okay.
logo, like, is, say Pepsi Cola or Coca Cola in their own unique writing style, right? I don't know if they're strictly going to protect the font itself, but like something that kind of looks like the Pepsi writing and in the logo and with the color scheme, like basically set up like that, that's definitely going to be an infringement.
Sure.
Um, and similar thing, it's not really as much about the writing style as it is like the logo. And like, say something like Coca-Cola, you write out Coca-Cola in that writing style, that's the logo, and that has a very familiar look to it. Um, and so sometimes the rules are just a little bit different when it comes to famous marks, things that are household brands, and something that you might just start from the ground floor. But in general, yeah, I mean, that stylized text is part of the logo. That's part of it, and it should be considered. I mean, basically, what you want to do is look at whatever consumers are going to consider recognizable about your branding, and that's what you want to protect.
Yeah. So let's also jump into products. So a lot of
Yeah.
people are going to have products they've created. They want to patent those, right? Did I get that right?
Yes, in general, when it's a product that you have something about the product that's different from other products, then that's what you would potentially want to patent.
Now,
Exactly.
how extreme different does it have to be? Because I've always kind of laughed about, like, there's 50 million mouse traps out there, right? I'm sure there's the whole mouse trap thing, and somebody makes one little modification to it, and then they turn around and patent this new mouse trap. How different does my product have to be from other ones out there to be able to distinguish it enough to get a patent on it?
Okay, got it. Um, so before I answer that, let me just say that there are two types of patents. There's a utility patent and a design patent. Let me just clarify that, and then I could answer that specific question.
Okay.
So, utility patent is what we typically think of, and the examples you gave, what we typically think of when we're talking about a patent is it's for an invention. Like, you invent a mousetrap that operates in a different way and it works better, and it's about functionality and structure. Design patent is just about how the product looks. And
Hmm.
that's an important type of patent on Amazon. But let's just set that aside for a moment, okay? So when we're talking about utility patents, you want to know how different it needs to be. This is how it goes. It has to be new and non-obvious. And what that means is new means different in any way. So it's just not identical to things that exist before. If there are things that are identical to it previously, that's not going to be patentable because it's not new. But the second portion of it is a little more difficult. It has to be non-obvious, which means, okay, there's nothing identical to it. There are some things that are different about it, but now we're looking at, is it different enough? And what it has to be is kind of outside the range of what people would normally think to do.
Hmm.
If you're designing coat hangers, like, that you can make it bigger or smaller, but you generally make it in one standard size, and that fits most clothes, right? So someone coming along and saying, I have a coat hanger that's extra big for big and tall sizes, that's not going to be patentable because that's obvious. It's just
Uh,
within the range of how people typically vary something. So typically you change the size of something, you change the material, it's going to be obvious. If you're talking about something like a supplement, like you maybe add in a new ingredient, but it's kind of something that's well known for its properties. So say, for example, it's a weight loss composition, and you say, I'm going to put ginger in mine. Well, I mean, ginger is well known for its properties for soothing the stomach. So adding it to a weight loss composition is probably obvious. It's not, there's nothing unexpected there.
Yeah.
So generally there has to be something that's just outside the range of variation, something a little unexpected. But is this still confusing? Yes, of course it is. And this is actually the thing that we argue with the patent office about all the time. It's like, they'll say, well, that invention is obvious, and we'll argue why it really isn't, why people wouldn't think to do it in this way.
Yeah.
So, it's useful to help you eliminate a lot of things, which are just plain old obvious. No one would disagree that it's obvious to make a big coat hanger or a mini coat hanger, right? But for certain other types of products, we might disagree with the patent office, but often I give clients guidance on what I think will go through and what won't. I mean, based upon having done thousands of patents, I have a good feel for what's going to be problematic.
Yeah, and so I'm glad you brought up the kind of process that they go through. So let's talk about that. If I'm at what point in the process of me wanting to get a product patent, should I be going to you? Is it when I've first kind of designed it on paper, or wait till I get a prototype? Like, at what point should I be coming to you or somebody who handles patents to say, hey, I need to get this done? Or you might be able to say, it's not different enough. At what point in that process should I be talking to someone about this?
I would say at as early a point as you see clear value, right? Because sometimes you're at the early stages and you're like, well, I think a product in this niche would be useful and blah, blah, blah. At the point at which you say, hey, I've actually come up with something that I think is going to be different and I think other people are going to want to copy, then that's the point that we ought to be talking about it. And sometimes those differences aren't there at the early stages. They come about as you design and prototype the product and say, you know what, this release lever thing that no one else has, this is what's making it work, and this is something that I think customers are going to want, and therefore we should look into protecting it. So I would say at as early a stage as you know that you have something that is potentially important, valuable, right? But you definitely want to do it before you make the product public. And that's the bigger trap. It's like whether you do it like when you first thought of it or whether you apply for the patent later on when you're building prototypes, that doesn't matter so much. But I think more important is that you want to apply for a patent before you make the product public.
Okay.
And I mean, there's the expected reason for that, which is, well, yeah, because you don't want anyone to steal your idea. But there's another reason, another legal reason, and that is that once you make the product public, if you haven't already applied for a patent, you immediately lose the rights in most of the world to ever patent it. It's just the way the patent laws are, is that if it's called absolute novelty. If a product isn't, if the product has been previously publicly disclosed, then it's too late to patent it in most countries in the world. In the US, different rule, there's still technically a grace period where if you make the product public and you haven't applied for a patent within 1 year, then it's game over. So, you could release the product and apply for the patent a few months later, and you haven't technically lost the rights to get a US patent at that point. It puts you in a worse position, but it's not game over yet. But let's say you did that, you've already lost the rights to do it in Europe and many other places.
So Rich, if I'm creating, or let's say I'm designing a product on, a CAD system, or I'm writing it on paper or whatever, and I come up with this great idea and I want to get it patent, but let's say we go ahead and go with the patent, but I decide, I'm not going to actually create it, like actually physically make it, does that patent still hold up? Do I still own that patent? Can I still protect it even though there's not a physical product made to match that patent?
Yes, you don't actually have to make a product in order to protect it. And probably 9/10 of the patents out there have never been made. Like no one has ever made that, that invention just as described in the patent. So basically, when we draft the patent application, we need to explain it in enough detail so that people in the field would know how to make it from our description. So we didn't leave it to chance. Like we can't just say like, I'm patenting an anti-gravity machine without explaining how it works, right? So same thing is when you're applying for a patent on any given product, we need to explain it with enough detail so that they understand how those pieces would go together and what it would be like. And then we've satisfied the requirement. We don't actually need to build one in order to get a patent.
Gotcha.
And I know that's a misconception.
Yeah. Like, yeah, that's why I was asking, because I was kind of curious.
People, I mean, people think like it's like maybe I'm dating myself with this example, but they think it's like you walk into the patent office with your invention on your lap, and then like they call you into a room to present it, and you walk into a room where there's like a long table of judges, like in the movie Flashdance, and you get out there and you demonstrate your invention, and they kind of look at each other and they whisper back and forth, and they kind of nod their heads, and they either accept you or reject you. And that's what people think it's like. But the truth is everything with the patent office is in writing. So, it's
I'm glad you said that. I'm glad you said that. So why don't we talk about the process? What is kind of a high level view of the process for a patent? Then is it the same or different for a trademark? Why don't you step us through both those processes?
Okay, absolutely. So, yes, they're similar. And so in both cases, patent and a trademark, you file an application. Either you file a patent application or a trademark application. The big difference is that a trademark application is fairly simple, but it's nuanced in that if you look at a trademark application, you might say, hey, I could do that. And some individuals do successfully get through the trademark process. But a lot of times, it's the experience of an attorney who's done thousands of these that knows how to steer it in the right direction that can make a big difference later on and can make a difference in it getting approved or not. So trademark application, pretty simple, but pretty inexpensive. On the other hand, patent application is rather complex, expensive, and not at all possible for you to do it on your own and do it well. So patent application is a detailed document that explains in detail what the invention is, how it's different from things that have been done before, and really sets the stage for why it's worthy of a patent. And so a typical patent application might be 20 to 50 pages with several drawings or dozens of drawings, depending on what it is you're patenting. It just goes into technical and legal detail what the invention is all about. And so you get that together, you get the patent application together, it gets filed, and when it's filed, it becomes patent pending. So you hear patent pending, you see products marked patent pending. That's really what it means, is that the patent application has been filed, but it hasn't yet been reviewed to see if the person is going to get the patent. So you file your patent application, it becomes patent pending. That also establishes your priority toward getting the patent, so that then people see what you're doing and they try to apply for their own patent, you'd be ahead of them. Because our system is now a first to file system, which means the first person to apply for the patent is the one who will be entitled to it. So you filed your patent application, you've established your priority. Now the next thing is that it's going to get in line to be reviewed by someone at the patent office known as an examiner. So eventually the examiner is going to examine it. They're going to review it. They're going to do their own research to see what else exists that's similar to it. And they're either going to accept it or reject it. If they accept it, then it gets approved, or it's called allowed. And you pay some fees to the government, issuance fees, and then they issue your United States patent. And then you have now in hand an issued United States patent. So then you're patented. If it gets rejected, then they need to give us their reasons for rejecting the application. And once they do, we can decide, or I typically decide with clients, whether it's worth proceeding, whether it's worth arguing to get the patent approved. And most of the time it is. I mean, very often we'll get an initial rejection that we know we can get past, and so we'll argue and we'll get the application through.
Gotcha.
And so generally that's the process for patenting. Now for trademarks, it's similar. We file the application, it gets reviewed. The only real difference is once it's approved, if you're not already selling products under that mark, then you'll need to supply proof to the trademark office that you're using this name in order to complete the registration process. So like your question about hey, do you need to have the invention built in order to get the patent? Not true for patents, but with trademarks, in essence, it is. You need to be using the mark in order to complete the registration. You can't just reserve a name and just have it registered and hope maybe someday someone else is going to use that name. You need to actually be using that name on products. And so once you supply proof that you're doing that, then you can complete the registration process and get the registered trademark.
Now, as far as using a name on a product to be able to protect that trademark, what extent do you have to go? I mean, if you got, let's say, I don't know, 5 items created with it and you are currently trying to sell them, but let's say they're not selling, but your intent is you're trying to, it's listed on Amazon. Is that still enough to protect that trademark?
Well, I mean, you could, generally the way it works is when you're applying for a trademark, you apply in a category, in at least one category for the products that you plan to use. And so in order to get protected in that category, you need to start using it in that category. So, I mean, you can get extensions and maybe not immediately start using it in like a second or third category that you've applied for, but you need to keep getting extensions, and it costs money, and you can only extend it out for about 3 years from when you start. And so generally what you want to do is apply only in the categories that you expect to start using it within the next couple of years.
Gotcha.
And you have to pay for each category too. So, sometimes people come to me and say, hey, I want this trademark for all categories. Well, I mean, a trademark like that doesn't exist. You don't protect the name in a vacuum just for anything. You protect for certain products. But they might say, I want it for use with shampoos, conditioners, which might be in one category, but moisturizing creams might be in a different category. And I don't know, soap might be in a third category. So then you want to specify the ones that you reasonably intend to start using it in and apply for those. You can always go back and apply for the other ones later in a separate application. And if you look at famous brands, that's what they do. I mean, Harley Davidson probably has trademarks for motorcycles going back 100 years or more. But maybe 5 years ago, they trademarked Harley Davidson for toothbrushes because they decided they were going to start branding or licensing Harley Davidson on toothbrushes. So it's something that can expand over time. And most of those famous marks like Harley Davidson or Coca-Cola, et cetera, they have hundreds of trademarks.
Yeah. Anytime they're going in another category, it sounds like they need to go out and protect it in that category, right?
Exactly.
Yeah. And so
but you got to start somewhere. You start with one typically.
Yeah, I gotcha. So why is it important to get patents and trademarks?
Well, I mean, there's a few reasons. It's not always important to get patents and trademarks.
Okay.
I think one of the best reasons to get patents and trademarks is that when it's time to sell your business, having the patents and trademarks actually be a multiplier of the value that you're offered for your business. Owning the IP can make a big difference, because if you don't own the IP, they'll look at your company as if, well, what would it cost us to create a company just like yours, with the same level of customers, same level of revenue? And that would be the comparison for how they value your business. If you own the IP, then they can't do that. They can't just create a business in parallel making the same products if you own the patents to it. So then what they're purchasing is the upside. They're purchasing not the market share that you've obtained or attained, but the whole rest of the pie where it may be possible for them to get even more customers. You know, and people buying your business typically think that they're smarter than you, right? So they think like, yeah, we can take that and we can grow it into something even bigger. So that's what you're selling, is you're selling the upside, and that's what you're getting paid for when you own the IP. So that's one really good reason for having IP or having patents and trademarks. Another one, if you're selling on Amazon, is that I'm sure every one of your listeners either has had personal experience or knows someone who's had a listing shut down because of a patent.
Yeah.
And it sucks when it happens to you. And a lot of times it's because it's unfair. That there may be, you know, someone makes an IP complaint with their patent, and maybe Amazon really takes their word for it. And it's like, well, I don't know, it's kind of close, but yeah, we'll just shut them down anyway. And so Amazon seems to be deferring to IP owners. And for that reason, it pays to be the IP owner. It pays to be the guy with the patent because Amazon tends to be taking that person's side. So I think that's the other good reason for Amazon sellers to get patents.
Yeah, that's good information. And then let's also talk about Rich. Rich has this book out, and I'm going to give everybody the title. It's ABA Consumer Guide to Obtaining a Patent. Rich, why don't you tell everybody a little bit about what's in the book, kind of what it covers, and how they go about finding that book?
Okay, great. Well, I mean, first of all, you can find it on Amazon, and it's less than $20. And really what it is the American Bar Association asked me to write a book explaining to entrepreneurs in plain English how patents work. And that's just what I did. I mean, if you found me reasonably easy to follow on this, which I think I'm pretty good at taking this stuff and breaking it down and making it understandable, then that's how the book is written. And that's what the book does, is it takes all of these concepts and makes it something that you could sit there and read, probably read the whole book in about 4 hours. And if you did so, you'd know more than 99% of sellers how patents work. And I mean, I believe that patents is probably the thing that sellers know the least about, that if they understood better could have the biggest impact on their business. That's my contention. So I think it pays to learn about this stuff. I agree
with you.
Yeah.
Yeah, absolutely.
And so that's why I wrote the book. And so again, it's the ABA Consumer Guide to Obtaining a Patent. It's worthwhile. I mean, also I talk about this stuff on my podcast, Innovations and Breakthroughs. I talk with people who've had a path towards getting products out there on the market. Or in other words, they tell the story of the path they took getting their products on the market. And I've had some really great people that you and I know on that podcast. So
absolutely. What was the name of that podcast? Make sure to tell everybody the name.
The name of the podcast is Innovations and Breakthroughs.
There you go. Make sure you take a look for that. So Rich, I also want to know, and so does everybody else, before you became an attorney, what did you do?
Well, what did I do? It's interesting. So, I mean, first of all, what I did is I studied electrical engineering. So in order to be a patent attorney, you need to be an engineer and a lawyer so that you can understand the technology and understand how to explain it and argue it. But initially I was studying electrical engineering, and I also started a business. I was actually selling beauty supplies. I went into salons in the area of where my college was, and you know, I just basically did cold selling. I went in and I sold products that they used in their trade, the different tools and the different chemicals and nail files and things like that. So I had that business going, and I was very interested in business and in marketing while I was in college, although studying electrical engineering. And I was wondering how to connect the dots between the two. And I found out about patent law. So I finished up electrical engineering, and then I went to law school. And, awesome. And the rest is history.
That's awesome. That's a really good story. So speaking of stories, you've got to have a funny story that had to do with either a patent or trademark somewhere in your book of knowledge of people that you've dealt with, without giving away. Obviously, we don't want the person's information or the product or something, but you give us a little story about something that was pretty funny there that happened, Rich.
Yeah, I mean, there's so many. Actually, the thing that that occurs to me though is just something that was immediately funny. Was I had an office in Los Angeles years ago, and I had a client who came in for the first time. He was an older gentleman in his 70s, and it's like I sat down, we started to talk, and I was like, well, what's your invention all about? And he handed me a walnut and nutcracker, and he said, oh, well, actually, he had a bunch of nuts in a plate, and he passed it over, and he said, here, would you like one? And he passed me the nutcracker, and I said, okay, sure. I took a walnut, I took the nutcracker, and I cracked it. And the second that I cracked it, immediately what was in my hands was the nut fragments and a condom. So, basically what he devised was a way to get a condom inside of a walnut so that you had a funny gag to play on guests at your house, where they go to crack a nut and all of a sudden they've got a condom in their hand. And it was a process that he had for doing this, and he wanted to patent it. And I was like, well, how are you going to monetize that? And he didn't really care. He just thought it would be fun to patent something. And so I got him a patent on that, and it's called Condom and Nut Novelty. And he was very happy to have that patent. I mean, in general, I like to see that there's a business purpose for a patent, that there's some type of way that the client intends to monetize it. But in this case, he was happy to get a patent on his Condom and Nut Novelty.
That is funny. That is absolutely hilarious, Rich. I had not heard that story, and you and I have talked a bit, but that's a great story. That should be. I
haven't thought about it in a while, and it's funny. You said you have like a funny story, and like that just popped into my head.
That's your new icebreaker at any Amazon get together from now on? That's great. Well, Rich, exactly. Thanks for being on the show. But before we go, let's tell everybody how they get a hold of you, and once again, plug the book and social media, everything on. If somebody wants to contact you regarding patents or trademarks, give them the information.
Yeah, well, in general, you can go to the website for my law firm, which is goldsteinpatentlaw.com. Okay. And there's actually a lot of great educational videos there, too, that explain how the process works and that are free. And also, I mean, if you go to the website, you can then get in contact with my team to see if it's a match to work together. So if you think that there's something that we might be able to help you with, then you can contact my team through the website, goldsteinpatentlaw.com. You could also email my office by emailing welcome@goldsteinpc.com. And the podcast is Innovations and Breakthroughs that you can get on iTunes and through other typical podcast
awesome
platforms. And the book, again, is the ABA Consumer Guide to Obtaining a Patent, and you could find that on Amazon.
Perfect. Now I'll make sure to put all the links in the description so everybody can find it if they don't remember. And again, Rich, thanks again for being on the podcast. I really appreciate it.
My pleasure. And you know what? I'll send you a link to the patent for the Condom and a Nut Novelty. So if anyone wants to just take a quick look at that, I'll get that link to you as well.
I'll be sure to put that in there. All right. Thanks a lot. I really, really appreciate you being on.
My pleasure, Rob.
Please subscribe to our YouTube channel, and for more information, please visit feedbackwiz.com.